Namaskar. In today's case note, we shall be discussing the latest judgment passed by 5 judges bench of Honorable Supreme Court, that is Neeraj Dutta versus State Government of NCT of Delhi, with regard to the culpability of public servant inferred from circumstantial evidence. Now, the question under reference before Honorable Supreme Court was whether, in the absence of evidence of complainant or direct or primary evidence of demand of illegal gratification, is it not permissible to draw inferential deduction of culpability or guilt of a public servant under Section 7 and Section 13(1)(d), read with Section 13(2) of the Prevention of Corruption Act 1988, based on other evidence adduced by the prosecution? Now, how this question was posed can be looked by the procedural history that by order dated 27th of August 2019, a 3 judges bench of Honorable Apex Court referred the question of law to a larger bench. Honorable the Chief Justice of India referred these cases to a 5 judges constitution bench. Reference was made as observed by Honorable 3 judges bench was that 2 3 judges benches of this court in the case of B. Jayaraj versus State of Andhra Pradesh and P. Satyanarayana Murthy versus District Inspector of Police, State of Andhra Pradesh and another are in conflict with an earlier 3 judge bench decision of this court in M. Narsinga Rao versus State of AP regarding the nature and quality of proof to sustain a conviction for the offences under Section 7 and Section 13(1)(d), read with Section 13(2) of the Prevention of Corruption Act 1988, when the primary evidence of the complainant is available. Hence, it was deemed fit to refer it to a larger bench. Now, if we see all the 3 cases, the common thread in all the 3 cases was that the complainant was not accessible to give evidence, hence direct evidence was lacking. However, if we see the distinction in B. Jayaraj case, the complainant did not back the prosecution and was ruled hostile. In P. Satyanarayana Murthy case, the complainant died before 7 witnesses were examined, and in M. Narsinga Rao, the prosecution witnesses had turned hostile. Now, on account of the different scenarios, in B. Jayaraja and in P. Satyanarayana Murthy case, the court acquitted the accused. However, in M. Narsinga Rao, despite 2 witnesses being deemed hostile, it was discovered that the accused had willingly received tainted money notes, and this court upheld the conviction of the accused. 2 prosecution witnesses were hostile, but other witness evidence showed a demand for unlawful satisfaction. As the essential facts were proven, the presumption for payment of acceptance was relevant and was not rebutted. The legal presumption under Section 20 of the Act was likewise raised and not rebutted. In the foregoing context, the larger bench and the Constitution bench were referred to. Now, the relevant provisions considered under Prevention of Corruption Act 1988 prior to the amendment by the Constitutional bench were Section 7, which speaks of public servant taking gratification other than legal remuneration in respect of an official act. Honorable Supreme Court also gave out the ingredients of Section 7 of the Act, that the accused must be a public servant or expecting to be a public servant. He should accept or obtain or agrees to accept or attempts to obtain from any person, for himself or for any other person, any gratification other than legal remuneration as a motive or reward for doing or forbearing to do any official act or to show any favor or disfavor. Section 13(1)(d) was also discussed. Section 13 speaks of criminal misconduct by a public servant. Section 13(1)(d) of the Act has the following ingredients which have to be proved before bringing home the guilt of a public servant, namely, the accused must be a public servant by corrupt or illegal means, obtains for himself or for any other person any valuable thing or pecuniary advantage, or by abusing his position as public servant, obtains for himself or for any other person any valuable thing or pecuniary advantage, or while holding office as public servant obtains for any person any valuable thing or pecuniary advantage without any public interest. To make out an offense under section 13(1)(d), there is no requirement that the valuable thing or pecuniary advantage should have been received as a motive or reward. An agreement to accept or an attempt to obtain does not fall within section 13(1)(d). Mere acceptance of any valuable thing or pecuniary advantage is not an offense under this provision. Section 20, which speaks of presumption where public servant accepts gratification other than legal remuneration, was also discussed, and it was observed that the statutory presumption under section 20 of the Act is available for the offense punishable under section 7 or 11 of clause A, B of section 1 of section 13 and not for clause D of subsection 1 of section 13. Since this case focused on the quality of the evidence for proof of demand and acceptance of an illegal gratification before a public servant can be held guilty of an offense under section 7 and or section 13(1)(d) of the Act, relevant provisions under Indian Evidence Act were also discussed and considered. Section 3, 4, 59, 60, 61, 62, 63, 64, 65, and 154 of the Evidence Act were discussed. Presumption under section 4, section 79, 80, 81, 83, 85, 89, and 105 of the Evidence Act were discussed. It was also observed that presumption vis-a-vis section 20 of the Act 1988 was also dealt, that speaks the presumption of illegal gratification by public servants. Subsection 1 and subsection 2 use shall be presumed unless proven otherwise. The clause deals with a legal presumption in the nature of a command, that it has to be presumed that the accused accepted the gratification as a motive or reward for doing or foregoing any official act, etc., if the condition in the first part of the section is met. Section 20 of the Act merely requires proof that the accused received or agreed to take gratification during trial. The section does not require direct evidence. It just requires proof that the accused accepted or agreed to take gratification. Accordingly, law relating to circumstantial evidence was also discussed. Legal position with respect to the reliability of testimony of hostile witnesses and conviction of the accused in the presence of corroborative evidence was also clarified. After discussing all the relevant provisions and the plethora of judgments, the position as emerged from the discussion so made by Honorable Supreme Court was summarized by Honorable Supreme Court as proof of demand and acceptance of illegal gratification by a public servant is a sine qua non for establishing his guilt under section 7 and 13(1)(d) clause 1 and clause 2 of the Act. To prove guilt, the prosecution must prove first, illegal gratification was demanded and accepted. This can be proven by oral or documented direct evidence. Further, circumstantial evidence can prove demand and acceptance of illegal gratification in the absence of direct oral and documentary evidence. To prove a public servant demanded and accepted illegal gratification, consider the following. If the bribe giver offers to pay without demand from the public servant and the later accepts the offer and receives the illegal gratification, it is a case of acceptance under section 7 of the Act. In such a circumstance, there is no need for prior demand by public servant. If the public servant makes a demand and the bribe giver accepts and tenders the demanded gratification, it is obtainment. In obtainment, the public servant prior demands illegal gratification. It is an offense under section 13(1)(d), clause 1 and clause 2. In clause 1 and clause 2, the prosecution must prove the bribe giver's offer and the public servant's demand. Simply accepting or receiving an illegal gratification is not an offense under section 7 or section 13(1)(d) of the Act. Section 7 of the Act requires a bribe giver offer that is accepted by a public servant in order to constitute an offense. Similarly, a prior demand by the public servant when accepted by the bribe giver and a payment is made would be an offense of obtainment under section 13(1)(d) of the Act. It was also observed that a court may infer a demand, acceptance, or receipt of an illegal gratification only when the underlying facts are proven by oral and documentary evidence. On the basis of the evidence, the court may raise a presumption of fact when deciding whether the prosecution demonstrated demand. A presumption of fact is subject to rebuttal by the accused, and in the absence of rebuttal, the presumption remains. If the complainant turns hostile, dies, or is unavailable to testify during trial, demand of illegal gratification can be proven by letting in the evidence of any other witness who can testify orally, in writing, or by circumstantial evidence. The trial does not abate or acquit the accused public servant. Section 20 of the Act requires the court to presume, based on the evidence, that Section 7 illegal gratification was for a motive or reward. The presumption must be raised by the court as a legal presumption or a presumption in law. The presumption can be rebutted. Section 20 does not apply to Section 13(1)(d), Clause 1 and Clause 2 of the Act. It was also clarified that the presumption in law under Section 20 of the Act is distinct from the presumption of fact in point E, since the former is mandatory and the later is discretionary in nature. Therefore, it was ruled that there is no conflict between the three judges' bench decisions in B. Jayaraj and P. Satyanarayan Murthy and M. Narasimha Rao regarding the nature and quality of the proof necessary to sustain a conviction for offences under Section 7 or 13(1)(d), Clause 1 and Clause 2 of the Act, when the complainant's direct evidence or primary evidence is unavailable due to his death or another reason. Even if a hostile witness is cross-examined, his evidence must be weighed with care and circumspection, and credible testimony must be acted upon. The judge must examine the credibility of the evidence to prove the case. A witness hostility does not automatically discredit his testimony. Even hostile evidence witness may be considered if it is corroborated by the case facts. Thus, hostile witness testimony can be used to get a conviction if corroborated by other reliable evidence. Accordingly, the reference was answered and orders were to be obtained from Honorable the Chief Justice and placed before the appropriate bench to take a decision on the factual aspects of each individual case. So this was all about the latest case law pertaining to culpability of public servant inferred from circumstantial evidence. So till we meet next, namaskar.